Mr. O'Neill.
Chairman Tillis, Ranking Member Coons, and members of the subcommittee, thank you for the opportunity to testify before you today on behalf of Cleveland Clinic. I am the Executive Director of Cleveland Clinic Innovations, the group within Cleveland Clinic that helps translate the discoveries made by Cleveland Clinic staff into products available to patients and consumers. In my current role, I help my coworkers bring their inventions to market, and I'm here to share some real-world insight how our experience with patent litigation in recent years is impacting our work. We have directly participated in recent patent infringement cases, including recent appeal to the Federal Circuit that was rejected with the court finding, I quote, "While we greatly respect the PTO's expertise on all matters relating to patentability, including patent eligibility, we are not bound by its guidance," end quote. We received this final decision about 2 months ago. Court decisions like our Cleveland Clinic versus True Health have created new levels of uncertainty for us, and I believe for innovators across the country. That uncertainty has a very meaningful impact on our ability to develop and bring new advances to market for use with patients and consumers. Regardless of how novel a product might be, the courts seem to suggest that any product that utilizes a naturally occurring phenomena, like diagnostic tests, could be subject to invalidation in court. Furthermore, the Federal Circuit has outright questioned the weight of the policy issued by USPTO, which casts doubts in the innovation community what protection a patent actually provides. These questions about patents hurt the ability of Cleveland Clinic Innovations and other innovators to bring new products to market. The ability to get patentable protection, IP protection, is the first factor in our assessment of whether a product can reach the market. If an invention can't get intellectual property protection, usually that is a fatal flaw and the invention is abandoned at that point. As I describe in my written testimony, there are potential pitfalls in making changes to federal patent law. So like many others in these hearings, we advocate for balance. Parts of the research community have expressed concern that the proposal put forward by the committee could become a barrier to progress. These concerns are important to Cleveland Clinic and the researchers we support. We would be concerned about any scenario in which an individual genes would be eligible for patenting, and we appreciate the committee's comments during earlier testimony and again today sharing these concerns. In addition, like so many in the medical community, we are concerned about the cost of prescription drugs. Cleveland Clinic has vigorously supported the CREATES Act, which we hope will help bring generic drugs to market more quickly. We hope the committee will be careful to address these and other concerns with any legislative proposal that moves forward. As the committee moves forward, I want to offer the following considerations. 1, give greater standing to the guidance from the USPTO. It is the federal entity that provides guidance on patentable subject matter and issues patents. A patent issued by USPTO should represent the approval of the federal government that an invention meets the standards of the federal statute, not the beginning of a protracted legal battle. 2, clarify the eligibility of life science and diagnostic products under Section 101. Federal court decisions have called into question whether any innovative discovery that utilizes inventive steps related to naturally occurring phenomena of the human body would be eligible for patents. This uncertainty has a chilling effect on the field absent greater clarity. And 3, protect the ability of researchers to continue their work. While patents are an important part of the field of innovation, those patents should not stand in the way of crucial cutting-edge research. We applaud the work of the committee to bring focus to these important topics. I look forward to any questions as part of this hearing or in the future.
Thank you. Dr. Spetzler.
Thank you very much for the opportunity to speak today. We at Caris Life Sciences have spent the last 10 years and spent over $400 million in an effort to try and cure cancer. During that time, we have made unprecedented discoveries in terms of how to use genetic and protein information to ideally find optimal treatment strategies for patients. It's been a long road, a very painful road. We have lots and lots of examples where foreign and domestic companies have completely infringed upon our intellectual property, given the murkiness of the current law. It really becomes very difficult then to continue innovation. It also fosters an ideal environment under which we don't share any information. So it is incentivizing us to keep secrets. The only effective strategy we have is try to maintain our position through trade secrets, which has a much longer and devastating effect on the advancement of science. Patents give us the ability to share information, broadly disseminate what we've learned, and enable more discoveries. It's how we're going to change things. We have to work together. There's no one group that can solve the problem of cancer. And so without an effective manner of patenting and protecting our inventions, we're going to see a rudderless ship just spinning around. I believe that the legislation that you've proposed is absolutely effective and efficient in creating a system that incentivizes more and great discoveries. Through the testing that we've done today, we've accumulated genetic information on 166,000 patients with outcome data on more than 100,000 patients. It represents the largest genetic and outcome database in the world. Yet there's nobody that is going to have that information if we can't protect it, and that is unfortunate. We do our very best to try to enable patient access to our technology and our information, and are very efficient at delivering it, but we could be much more effective if we in fact had patent protection that enabled us to fully optimize and protect our investments. I want to thank you for the opportunity to speak in front of you and deliver some time back to the committee. I know that we're very pressed.
Thank you all. We appreciate your indulgence. Dr. George, I think you read or went through your speech, but you did it at about twice the speed you normally talk, so that was very impressive.
Got out a couple minutes, tried to do my best.
This question is for Drs. Hill and Spetzler and Mr. O'Neill. And can you talk a little bit about the current jurisprudence? You know, we intend to abrogate some past jurisprudence. Can you talk a bit about how that has impacted and hindered diagnostic and life sciences industry?
Absolutely. I think what we're seeing in our experience at Genentech is a lot of uncertainty and a lot of inventions that are moving the needle as we try to find treatments that are closer to what the body's doing naturally, be absolutely unpatentable in the United States. So they're still patentable in Europe, China, and other jurisdictions. So what that means is that I'm already in a position to go to my business and how to tell them that while we have this amazing presence and we've had this tremendous contribution in the United States, we're no longer able to give them patent protection for these key inventions.
Mr. O'Neill, Dr. Spetzler, anything to add?
The work of translating discovery into commercial products requires the patent protection to justify the investment into those discoveries. And absent clarity, which exists today, we are not moving forward diagnostic discoveries to translate them into commercial products the way we would do otherwise.
I mean, there's uniqueness in this field as well because it's a highly regulated environment. So we are forced to disclose a lot of what we do in order to have the appropriate and very pertinent regulations that protect patient safety. So it creates a very difficult situation where on one hand, we need to publish and we need to disclose, and yet on the other hand, we enable competitors through that exact process.
Thank you. Dr. George, you had expressed a concern. I want to go back and make sure I understood in your opening statement about the possible risk of providing a patent for a gene. I'd like to maybe have you drill down on that a little bit, and then also if you could cite any examples in jurisdictions like the European Union or China where that's actually been realized based on a construct that I think is similar to what we're trying to head towards.
Sure. The point I was trying to clarify is that at issue is actually not the patenting of a single gene. At issue are the overly broad methods, observation, association patents that take that genetic information and wrap it up with a disease outcome or an observation that could diagnose a patient or target that patient for a particular therapy. That is the patent thicket I'm referring to, which prior to about 2012 was in place. Post-2012, I believe the data, the actual facts would show that the industry is currently experiencing renaissance in investment, expenditure, market capitalization, profitability, number of new drugs, et cetera, number of new diagnostics, number of new companies, et cetera. My concern expressed is that without some changes to the proposed legislation, that patent thicket would effectively be reinstalled, thus to the detriment of the industry and patients alike. And so just to be clear, that specific patenting of the gene is I agree with the comments, the opening comments, that that's really not the point here. I do think, however, that everybody is concerned, and I think rightly so, about the effective reinstatement of that gene patent thicket, which I do believe will have detrimental effects. As for ex-US, again, I'm not a lawyer, I'm not a patent expert. We do operate globally. In our industry, we're one of the more internationally active. And from my perspective, perhaps it's only my perspective, the United States is the absolute clear leader in precision medicine. There's nobody even close. I do not believe that the nuances that we are discussing about patent subject matter eligibility really matter when it comes to actual market competition and execution on a global stage. I'm glad Dr. Spetzler mentioned regulation. I think in particular in this industry, the kind of patent estate and the regulatory environment move together. And I think, before the state feeds one of the twin attack dogs of the incumbent, litigation or regulation, I think it's really important to understand what we're doing here and to whose benefit.
Thank you. Senator Coons.
Thank you, Chairman Tillis. Let me just, Dr. Hill, Dr. Marino, ask you quickly. Some have suggested we really ought to pursue a narrower reform agenda, one that just targets eligibility for medical diagnostics. Do you agree with that suggested solution? What are the consequences of doing that?
So
Instead of, I think it was Dr. George said, scraping away 150 years of precedent, I would argue
Right.
it's really more like 10 years of precedent. But instead of rewriting the fundamental definitions of Section 101, do something a little bit narrower. Help out medical diagnostics. Don't create problems for anybody else. Why is that not the right solution?
So thank you for that question.
It's called leading the witness here.
So for a couple of reasons. I think, first of all, the proposal that we are considering right now isn't going to sweep in anything obvious because we have 103 and 102 to take care of that. I think the other aspect of it is that medical diagnostics is not enough. When we really think about the future of personalized medicine, you need AI and bioinformatics. You also need to be able to pursue things as you get closer to nature, in addition to the diagnostic piece. So it is a convergence of multiple technologies that we really are truly at the cusp of seeing the convergence and taking it to the next step.
Dr. Moreno?
Yeah, I would agree with those comments. I would say that any legislation that's proposed should address future technologies. We don't want to come back and have to be in the same situation again. Diagnostics.
Does our proposal do that?
Yes, I think it absolutely does. I think, you've seen a lot of diagnostics, including the Cleveland Clinic, that had real, true implications for patients been invalidated. But I think in the future, you're going to see a lot of other technologies. You're going to see people revitalizing old drugs based on reanalyzing clinical trials and figuring out why some people responded and others different. There's going to be AI inventions and many other things we can't even imagine. We're at the cusp of innovation in this area, and the law should not get in the way.
Given the press of time, let me just try and get to one other point that seemed to emerge to me from your testimony. Mr. O'Neill, you spoke pointedly about literally abandoning research and development if you got to the point where intellectual property protection, meaning patent protection, seemed to be uncertain or unlikely. Dr. George, you described a golden age of research. The current law is working wonderfully. There's huge amounts of investment and research, and implicitly, you didn't say this exactly, but implicitly you're saying the change we're proposing would ruin a Garden of Eden of bioinformatics and great research that's leading to huge advances. Help me square these two.
Sure.
The thing that strikes me is that most of your inventions are protected by trade secrets. What you're talking about is patents. And there is a difference in strategy. Or am I missing something?
Ranking Member Coons, appreciate the comment, the opportunity to answer. Again, I can only speak to the financial facts and data and the amount of investment and the number of companies and the number of drugs. I believe it is unambiguously a very high growth era in the biopharma and diagnostic industries. It is unambiguously an area where more drugs than ever are being invested in. I think it really comes down to a difference of opinion of do strong patents directly equate to strong industry? And I think oftentimes, as if you kind of think back through history, over time, these things change. The complexity of what we do, the amount of information, the amount of invention that goes into it, I think, I'm not certain that stronger patents necessarily lead to a stronger industry. Again, I can only point to the data from these 3 or 4 cases, probably going back to Bilski till now. The result of those cases is...
How does the Ariosa case play into that?
Right, and actually I think Ariosa is a really good example of where I want to make sure that I'm clear. I'm not suggesting that the current state and the kind of gyrations we all go through in executing the current patent law is a Garden of Eden. It is complicated. There's a lot of lawyering. There's a lot of judicial decision making. The language that I read right here, I think...
There's thickets and there's thistles.
That's right. The language I'm reading here, I still think I'm pretty convinced would lead to more lawyering and would still have judicial decision-making involved. I do think there's an opportunity to craft it, to preserve, like I said, the policy that is good now as a result of the recent case law can be preserved by altering this language. That's what I would suggest. I'm sensitive to everybody's concerns that it's confusing and different parties, depending who you are, will be more sensitive to that than others. I think of it as kind of there's two ways to look at our industry. We could think about specific, narrow niche offerings, high prices, highly patent protected, or we could think about broad, collaborative, constructive uses of the information, combination of the technologies, lowering prices, increasing access, steaming ahead, leading in innovation, and bringing biotechnology to a scale that affects everybody. And so that's where I think the view of are strong patents good for industry, yes or no? I think it depends on your view of which of those worlds we want to have. My personal perspective, and again, I do believe it is backed up by absolutely unqualified facts. These decisions have led to a dynamism in our industry that we haven't seen before.
Does your company rely on intellectual property protection of any kind? Absolutely.
Yes.
Trade secrets or patents? Or
we have plenty of trade secrets. We have intellectual property. Since actually beginning in Bilski, when we founded the company, in fact, we placed a bet that the kind of trajectory of the patent landscape would shift a direction, something we felt was a little more sensical. We haven't been patenting up every single unique observation, every single unique association. I would point out in Vitae sits, we see more novel variation in the human genome than any company. Were we to go back to the association patents, my concern is all companies would feel compelled to rush to patent every single novel association, every single novel tie of an individual's genetic makeup to a potential therapy or a device. Again, I think it just depends on which vision of the future you want to subscribe to. I see where we're heading.
We have literally about 20 minutes left in a whole nother panel.
Yep.
And the chairman's been very, very tolerant. Can I just ask Mr. O'Neill to just briefly give comment on that? That is a fascinating observation. I appreciate your sharing it with us.
Thank you, Ranking Member.
And I appreciate the range of views here, sort of which keyhole you see a very complex.
You asked about research. At the Cleveland Clinic, research is continuing. Research is frequently funded by the federal government, and we appreciate all the funding we receive. I think at issue here is needing patents to support the investment that's required to translate research into commercial products. It's, in my view, it's a fact. That we will not move projects forward to translate into commercial products, not because we don't like them, not because we think patents add some kind of magic dust to them. It's because we will not receive investment into those either through ourselves or our partners or investors like private, in venture capital. Go ahead.
Does the absence of publication through patent issuance also impede advances in scientific research? So if I've got a great invention, he's got a great invention. I decide not to patent, I'm going to keep it a trade secret. He decides to patent. Everybody in the world knows what he's just patented. What I keep secret, nobody knows. That to me was my understanding of the origin of why patents exist is for the benefit of society, so that people don't keep trade secrets, so they put their information out into the public domain, and some temporary monopoly for that. And so yes, there's some industries where trade secrets work. In our industry, you need patent protection. My evident interest in this topic has caused me to run way over time. My apologies. Thank you. If you have further comments you'd like to share in writing with us, we'd greatly appreciate it. Thank you.
Thank you.
We, if we may, without objection, first off, thank you all. Apologize for the abbreviated format. We will certainly keep the record open and look forward to seeing your full written statements and any other information you'd like to submit for the record.